Here is the Wolda Salamma against the Director of Public Prosecutions of Bermuda and the Attorney General of Bermuda.
Mr. Fitzgerald.
My Lord, I appear for the appellant in this matter of my learned friend Amanda Clift Matthews. The respondents are represented by my learned friend Tom Poole, KC, by my learned friend Shakira Dil-Francois, the Solicitor General, by my learned friend Cindy Clark, the Director of Public Prosecutions, and by my learned friend Charlotte Pope Williams. And the appellant is attending by way of a link from the prison.
Yes.
So he can hear, but we won't see him. And my lords, could I just summarise matters? If I take you to the case at page 224, just summarise very briefly the background, and then come on to the grounds, the relevant statutory provisions, and the key cases. So just if I can take you to our case at 224, the appellant, as the court will know, was convicted of the premeditated murder of Malcolm Augustus. He was sentenced to life imprisonment with a minimum term of 25 years and a consecutive term of 10 years. And you have full details of those matters set out in the statement of facts and issues. The background for this case consists of these two key decisions. The first, which we've set out at 1.4, the Trott decision. In that case, the Supreme Court of Bermuda ruled that the jury selection process provided for under Section 519 of the Criminal Code was inconsistent with fundamental rights in Section 6.1 of the Bermuda Constitution to a fair trial by an independent and impartial tribunal, and the reason was that Section 513(2) permitted the prosecution to stand by an unlimited number of jurors, whereas the defence were only permitted to challenge 3 jurors without cause. And the court would have seen that there were numerous standbys in this case. The court held that a fair-minded and informed observer would conclude that there was a real possibility that the jury was biased in favour of the Crown, that there was an infringement of the principle of equality of arms, and that Section 519(2) was inoperative to the extent that it allowed for a disparity between the number of jurors the prosecution could stand by and the 3 challenges without cause afforded to the defendant. My Lord, there has subsequently been amending legislation, but obviously the question in this case is what effect does that ruling or that reasoning have on the conviction of this appellant. The next development is the case of Roberts, which we've dealt with at 1.6, and 3 individuals who sought to reopen their criminal appeals on the basis of the ruling in Trott. I will come on in detail to Roberts, but just to summarise very briefly, the Supreme Court dismissed the claim, and so did the Court of Appeal. The Court of Appeal dismissed the application to reopen, and it's our submission that in doing so, they laid down a very high test for reopening, effectively, that one would have to prove that there was actual bias and that it was operative to the extent that it was probable that the result would have been different if there wasn't actual bias. And I will take the board to that test. We say that that is a far too high a test for reopening, if reopening is the remedy. And then in this particular case, we've dealt with it at 1.7, the Supreme Court dismissed the appellant's claim for constitutional relief and held that the court was bound by the Court of Appeal's decision in Roberts. And the court held that the appropriate course was for the appellant to make an application to the Court of Appeal for leave to reopen his criminal appeal. So the constitutional motion was dismissed primarily on the basis that there was an alternative remedy by way of reopening, but also on the basis that he wouldn't satisfy the test laid down in Roberts. And the Court of Appeal followed its earlier judgment in Roberts. It held firstly that there was an alternative remedy, and that therefore, by operation of the Constitution, he having that alternative remedy must be refused relief and in any event upheld the very high test in the Roberts case. My Lords, against that background, we have the 4 grounds of appeal. Can I just refer to them and then try and summarise them in a more practical and pragmatic way for this board? So, firstly, that the Court of Appeal erred when it upheld the decision of the Supreme Court that, relying on the decision in Arbour Hill, the ruling in Trott did not apply to closed cases. That is, cases for which criminal proceedings had been concluded. Ground 2, the Court of Appeal erred when it held the finding of the Supreme Court that the test set out in Roberts, where there had been a breach of the right to trial by an independent impartial court, should be applied to his motion for constitutional redress. Ground 3, alternatively, the test adopted in the case of Roberts for reopening an appeal where there has been a breach of the right to trial by an independent impartial court was erroneous, that's to say far too high. And ground 4, that it erred in finding that the appellant had an adequate alternative means of redress.
So is that a reworking of the issues at page 218 in the Statement of Facts and Issues?
I'm so sorry, my Lord. Yes, well, those are the grounds of appeal on which leave was granted, permission was granted, my Lord.
Well, I thought the agreed issues are those set out at paragraph 5.1, page 218.
Yes, my Lord. This is simply a narrative of what happened in the case, because it was on those grounds that leave was then granted.
Do you want us to determine the issues raised at page 218?
My Lord, yes. I'm so sorry. Will your Lordship just give me 1 minute? Yes, whether or not that was right to accept the reasoning in Arbour Hill, whether or not the reopening that was applied in Roberts was correct, and if the approach to the test was incorrect, what is the appropriate test? And yes, my Lord, those are the. But can I just I hope assist the court by trying to summarise what we say is the key will be the key issue. So, firstly, we say, and this is really looking at Roman 4. We say there is no adequate alternative remedy, and certainly no adequate alternative remedy if the power to reopen is governed by a test as narrow as that propounded by the Court of Appeal in Roberts. So that's our first submission. Secondly, as to retrospectivity of rulings of unconstitutionality, we say that there is a presumption of retrospectivity, and in any event, we say that there must be sufficient retrospectivity to allow for a remedy in a case of apparent bias such as this. So that really, my Lord, is dealing with really 1 and 2 in the issues at 5.1 Roman 2. The third point we make, and this is really Roman 3 there, the Court of Appeal in Roberts and in the appellant's case adopted too restrictive a test for reopening, and that's, my Lord, the point. Effectively, they required both actual bias and the demonstration that it probably influenced the result. I can just give you the references to the relevant passages in Roberts, which is at tab 10. They are at paragraphs 189 of tab 10 and 191. And we say that test was the...
Doesn't your third point essentially run with the first? No adequate alternative remedy?
Yes.
Because, I mean,
yes.
if the Roberts test is defensible, wouldn't one draw the conclusion that is an adequate remedy? I appreciate you say the Roberts test isn't defensible.
Yes. Yes. My Lord, I'm trying to boil it down to the essence for this case, which is that we say there is apparent bias in this case in the manner in which the jury was selected. That is sufficient to constitute an injustice for the purposes of reopening. If it's not, then reopening doesn't provide an adequate remedy. There is an avenue, but not a remedy.
Well, what's the high point of your case? Is it that,
That's the high point.
is it that everybody who's been convicted under the old system has their conviction quashed?
No, my lord. No. We actually we do address that, because some of them, in some cases, well, there could be all sorts of reasons. One, there could be waiver because the person doesn't actually want to appeal doesn't want to have a retrial, for example. There could be situations where it's quite plain on the facts that though 519.2 was there, it wasn't operated or made no difference. So in those circumstances, it wouldn't be operative. So the mere fact that 519.2 has been declared unconstitutional doesn't mean that there is any form of injustice in every case, but it does open the door. We say that it gives rise in this case to apparent bias, a legitimate complaint of apparent bias, and.
So what you say is the requirement that the challenge, more than 3 challenges were made, or I mean, what engages it?
Yes, once more than 3 people are stood by, therefore they've.
Even if they're called back again?
Well, my lord, there seems to be a dispute about that.
Well, but just ignoring the dispute, even if they're called back and then challenged for cause?
Well, my lord, I accept that if they were called back,
yes,
and legitimate reasons were given, then there is a dispute, as the court will know, that the appellant doesn't accept that. That's what happened.
Suggested somewhere there are 40 or 50 cases.
Yes, my lord, yes.
That would engage your
Yes. Well, I think there's 40 or 50 cases where
the point's been taken.
The point could be taken, but it would then depend, my lord, on whether in fact in those cases the
Challenges were made.
Challenges
More than 3 challenges were made.
One were challenges made. 2, does the person want to appeal and get a retrial, etc. I mean, there are a number of reasons why. I mean, the board may say, well, that's ludicrous. Of course, everybody would want to appeal and get a retrial, but that's not necessarily the case if you're halfway through serving your sentence.
Well, it would apply to those people who had actually served their sentences. They could appeal out of time.
Yes.
So why is it limited to 40? Sorry. Is the 40 only those people who are presently in prison, or is it all those people who could potentially appeal?
I'm so sorry. Can I
Yes.
just rush it?
Yeah.
Yes, that's the number given by the Court of Appeal. So, in the Court of Appeal.
But I fail to understand how, if a law has been in existence for a substantial period of time and people have been convicted on the basis of that law, regardless as to whether or not they're still in prison, why they haven't got a right of appeal, if you're correct.
Well, my lord, I accept that they would, provided they could show that it was operative, that the injustice that we're complaining of was operative.
I mean, I've assumed that the 40 or 50 were 40 or 50 cases in which the Crown stood by more than 3 people, 3 jurors, potential jurors, but am I wrong about that?
My lord, I think we're going to have to check that.
All right.
Because
otherwise it's a rather meaningless figure, I think, isn't it?
you mean if it's just the amount of people who've been convicted?
Exactly.
Well, unless we know what it is, we can't really attach any significance to it.
Well, it's the figure given by the Court of Appeal.
I know, but what did they say exactly?
Shall we just get it? My lord, so... My Lord, could I, unless this is a... No, can I proceed and we come back to it? Because so, my Lord, those are the summary, and just the final point I'd respectfully make. I think I got to effectively require both actual bias and demonstration that it probably influenced the result. And I'd given you the references of paragraphs 189 and 191 in tab 10, and page 232 of the authorities. But the...
That's in Robert.
There's 508.
Yes. 508. Yes, so yes, if...
509.
509, sorry.
Was that right, Mr. Fitzgerald?
My Lord, I
There's
think...
paragraphs of Sir Christopher Clark's.
Yes, that's right.
189 and 191 are at
Yes.
509, I think.
That's right, of his judgment. And yes, if my lords go to that, I was going to analyse it later, but page 509, as your lordships observe, does not, however, appear to me that this is so exceptional a case that the appeal should be allowed, or that it meets the Arbor Hill exception or the English test. The contention that the Crown was in fact standing by jurors to fashion a jury in its favour, or that the result would probably have been different if those stood by had not been stood by, does not seem to me a strong one. There were, of course, 4 relevant Crown standbys where we do not know the reason why they were stood by, and where no reason seems to be mentioned at the time. And then it goes on to deal with the facts of the case. But if I can just take you the key passage, maybe 191. In short, looking at the matter as a whole, I cannot regard this case as coming within the wholly exceptional category, however precisely it is formulated. I recognise that we do not know why the Crown stood by 4 of those that it did, but in deciding whether the case is exceptional, it is legitimate to take into account whether, in relation to those where reasons were apparent or are now known, the proposition that the Crown was fixing the jury in its favour, and that if it had not, the result would probably have been different, carries any, and if so, what degree of conviction? In my view, it does not carry any real conviction, and certainly not amounting to a strong case. So that is being suggested as the criteria of what would be a sufficient injustice. And we say that apparent bias is sufficient. My lords, the final point we'd make is this is the 4th proposition we respectfully put, is that the board itself has the power to put the matter right. As in the case of Farrington, of course, the board had before it an appeal on a constitutional matter, but dealt with it by way of what it described as the Pinochet jurisdiction, the power in the final court to put right a real injustice, and exercise that power. So however the matter gets before the board can put it right, or it could remit the matter to reopen it and remit the matter to the Court of Appeal, because there are factual issues which would need to be determined, some of which my lords have already identified. My Lord Stevens has identified the point that what actually did happen in this case. On the affidavits, we've just got a conflict between the affidavits of the appellant in this matter and that of the DPP.
So you're saying we should treat it as an application to reopen?
Well, my lord, you can. The Ramanoop case in Trinidad makes it clear that a constitutional motion can be converted, and that was in the board. But my lord, in the end, the issue of substance is the question of retrospective application and how retrospective. I think there's no dispute that there is some element of retrospective application, because the substantial injustice test means that some cases will be opened where substantial injustice is shown.
The question is whether apparent bias is sufficient or whether actual bias is necessary for this purpose to reopen. And if actual bias, whether you also have to show it would probably have made a difference.
Yes, and my lord, we say that's
I know what you're saying, that it's an impossible test to satisfy.
It's
might as well have no test at all.
Yes, my lord, that's our submission. We've cited countless references from Lord Hope in Miller, Lord Bingham in Miller, from distinguished judges, some of whom are here in other cases. Apparent bias is all you can prove in many cases, and all that law is expected to prove, because you don't hunt down actual bias unless it's you can't.
Well, you can infer actual bias in some cases.
Yeah.
That doesn't seem to me absolutely impossible to prove.
No.
I mean, I think that maybe you're going to take us to the case of Scott itself.
Yes, my lord.
At some point. But that maybe.
Well, my lord. Then can I just, against the background of that summary of the issues, can I then just take you to the part 2 of the constitutional framework? I don't know if I could just take the court to the obvious point that Section 6 of the Constitution, 2.6, enshrines the right to trial before an independent and impartial court established by law, which is obviously...
Sorry, which page?
That's page 228, my lord. 228. And obviously that replicates the principle in the European Convention at Article 6.1. And then if, my lords, the Constitution...
Sorry, 228. I think.
No, I think you have, in our bundle it is 325.
Quoted on 228.
It's quoted on 228.
Yes, I'm just reading from the case where it's all set out.
Okay.
So, yeah, but your lordship's quite right. I should take you to the Constitution itself, and the Constitution itself is at tab 1 of the authorities, and one has that. You have section 6, but if I can just take you to the next relevant one, which is section 15, and
Page?
It's at page 329.
Thank you.
Enforcement of fundamental rights. If any person alleges that any of the foregoing provisions of this chapter has been or is being or is likely to be contravened in relation to him, then without prejudice to any other action with respect to the same matter which is lawfully available, the person may apply to the Supreme Court for redress. The Supreme Court shall have original jurisdiction, and then familiar things to hear and determine, make such orders, writs, etc., to deal with the case, provided that the Supreme Court shall not exercise its powers under this subsection if it is satisfied that adequate means of redress are or have been available to the person concerned under any other law. Just these brief points. We accept that the word shall not is strong there. In some of the other constitutions, such as Trinidad, it's may not. In the Bahamian Constitution, which this court dealt with in the case of Farrington, it was a mandatory refusal to, that's to say, shall not, the same type of language. And then its adequate means of redress are or have been available. And the case of Ramanup in the Trinidad case of Ramanup looked at that you've got to identify something which indicates that the normal remedies, in this case the normal appellate structures, would not be adequate. And we've made the point, my lords, we've made the point that the jurisdiction to reopen an appeal is, put it this way, uncertain and developing. That wouldn't necessarily be a reason, but certainly as interpreted in the case of Roberts, it would be inadequate to say that there was an available remedy. Rights have got to be practical and effective. We've quoted in the reply, if I'm allowed to refer to it, Lord Scarman, in the case of Riley, saying that the whole point of the Constitution is to enshrine the principle ubi ius ibi remedium. That the whole point of the Constitution is that the de facto rights which existed before the Constitution may have to be perfected by a fuller and more effective remedy. And we say that a constitutional motion would be a more effective remedy because you can decide facts, you have an appellate structure, and it's not purely a matter of discretion. But, my lords, at the end of the day, being practical in this case, if the power to reopen is given a sufficiently generous interpretation to cover apparent bias, then we wouldn't quarrel with that being the alternative remedy. And indeed, the appellant is keen that this point should be made. He sought to reopen after the Court of Appeal judgment. He sought to reopen before the Criminal Court of Appeal and was told, well, now that you're applying to the Privy Council in your constitutional motion, we're not going to look at it. So he did seek to avail himself of that remedy. And the key issue probably at the end of the day is there sufficient retrospectivity to cater for a case of apparent bias? Because we say there must be some remedy. So, my lord, that's slightly cutting through many of the learned debates, because what one can see in the cases is there are cases, and we've cited them, which say that there should be retrospectivity once the law has been clarified. There are cases such as Arbor Hill and Cadder and Joji, which suggest that it should be very much limited only to cases of substantial injustice. If the concept of substantial injustice is given a sufficiently generous interpretation, it wouldn't result in any injustice in our case. So, my lord, those are the submissions. So, if I can then take you to Trott at tab 9 of the bundle and just briefly show you that. The case of Trott is you see the facts are set out about the jury selection at paragraphs 7 and...
Sorry, the page...
Page 429, my lord. E-bundle, page 429. Paragraph 7, the presiding judge addressed the potential, advising them to consider whether a reasonable observer would find their presence on the jury to give rise to appearance of bias. Thereafter, the jury selection began, during which counsel for the DPP stood by...
You're reading it.
Page 430 at the top, my lord. Does my lord have paragraph 7?
407, thank you very much.
So sorry, my lord.
My fault. Yes, got it.
Yes, does your lordship see thereafter?
Yes.
Thereafter, the jury selection began, during which counsel for it stood down a total of 10 jurors. Out of the 10, all of them appeared to be people from Afro-Caribbean descent, and 9 of them were male. The plaintiff is an Afro-Caribbean male. And then 8, the plaintiff's counsel advised the presiding judge intended to challenge the validity of the Crown's use of the standby, so that was done during... Of course, there are a whole load of cases which say you shouldn't do that, but you shouldn't be challenging constitutionally halfway through criminal proceedings, but clearly it was done. And that indicates the need, we say, for flexibility. And then at 9, at the hearing of this matter, both counsel agreed that the court should approach this as a matter of principle and not based upon the allegations in relation to the motivations behind the selection of particular jurors. Accordingly, the result in this judgment is dictated by the terms of 5192 of the Code, and not by any consideration that the exercise of the right to stand by was any used in this case.
Don't the facts of this case show that you might well have a situation where it was possible to infer motivation in using the power to stand down?
You might
I mean, we don't know the full facts here, but just on the bare fact that a large number of men, of Afro-Caribbean men, were challenged and nobody else.
Yes.
You might well be able to draw an inference that it was an attempt to skew the jury in a racially biased direction.
Well, it would be open. It would be, yes. My lord, if it was that uniform, I accept that. Yes. But well, your
I'm just raising that now because if right, it suggests that a test of actual bias, if you like, as the first limb is not necessarily impossible to satisfy.
Well, one just doesn't. What we do know, my lord, is that the DPP is privy to all sorts of information that the defendant is not, and they say that we need to know that there's this information. So we just don't know what might be the motives behind it. But I accept, my lord, there might be patent cases
where if it wasn't rebutted, you might draw an inference.
My lord, I accept. Yes.
Challenging all women in a rape case,
Yes.
or challenging all men, or whatever.
My lord, yes.
Standing by them.
My lord, I accept them that there are cases where it may be so patent that you can draw the inference. What the problem is that if you've got an unlimited right to challenge and you've got information which is not accessible to the defence, there is the appearance, we say, of bias. But my lords, then there's the judgment. Well, can I just take the court to there's a recitation of Porter and McGill test at paragraph 30, page 438, and then the apparent bias, so that was all that was being considered, the appearance of bias. And then at paragraph 39, page 444, in conclusion, it is my view that section 519(2) of the code...
What's the page number?
Page 444, my lord. So, does my lord?
Yes, thank you.
Yes. In conclusion, it is my view that section 519(2) of the code is so heavily weighed in favour of the Crown that a fair-minded and informed observer would conclude there was a real possibility that the jury, selected by the exercise of the Crown's right to stand by, was biased in favour of the Crown. It follows that this conclusion necessarily means that the accused person is denied a hearing by an independent impartial court and is sufficient to establish a breach of section 6(1) of the Constitution. It also follows that the provisions of section 519(2) of the code can no longer be operative, as they are inconsistent with the fundamental rights established by section 6(1) of the Bermuda Constitution. And it goes on to deal with equality of arms. I don't think I need do more than refer then to 59 and 60, page 450, my lords, under the conclusion. Having regard to the reasons set out above, I am satisfied that the disparity between the accused persons and the Crown's right to challenge jurors gives right to a real possibility that the jury may be biased in favour of the Crown. Such a state of affairs offends the appearance of impartiality on the part of the jury, which is an essential element of the fundamental right to a fair hearing by an independent and impartial tribunal, guaranteed by 6(1) of the Bermuda Constitution. It follows that the provisions of section 519(2) of the Code are inconsistent with the fundamental right to a fair trial established by section 6(1). I am also satisfied that the extreme disparity created in the jury selection process also results in the infringement of the principle of the equality of arms by making the position of the accused extremely weaker than that of the Crown, and results in a breach of the right to a fair trial under Article 6 VCHR and the right to a fair trial established by Section 6(1) of the Constitution. So it's both equality of arms and the appearance of bias infringing trial by an impartial tribunal. So that's the ratio. And then really, my lords, we've summarised that in the case at 4.1 to 4.3, page 230. Can I then next take you to the judgment in Roberts? Because as I've indicated, three people, three individuals who had exhausted their rights of appeal sought to rely on the judgment in trial by making an application to the Bermuda Court of Appeal to reopen their criminal appeals, but the Court of Appeal dismissed those applications. We've set it out, we've summarised the key findings at 5.2 of the case at page 230. But my lords, can I just take you then to the key passages? Firstly, the court found that the Court of Appeal had implicit power to reopen a criminal appeal if a number of conditions were met. Circumstances were exceptional, made it appropriate to reopen the decision. There was no other effective remedy, and the accused would suffer substantial injustice if it did not do so. That is set out in the judgment at paragraph 69, page 481, under the heading Conclusions on Reopening. It says there the President Lord Justice Clark says, as it seems to me this court should recognise, as in effect it has already done, that it has an implicit power to reopen an appeal, and that it may, but is not obliged to do so, if one, the circumstances are exceptional, make it appropriate to reopen the decision, notwithstanding the rights and interests of other participants and the importance of finality. Two, there is no other effective remedy, and three, the accused would suffer substantial injustice if it did not do so. And then, can I just take you then to paragraph 73, where they deal with the procedure. In future cases where leave is sought to reopen the appeal, so this is page 482, the court should, if it deals with matters separately, either refuse leave if satisfied that there is no adequate basis for thinking that the matters relied on might cause the court to give leave to reopen the appeal, or indicate that it is prepared to consider whether or not leave should be granted at some future hearing without actually granting leave at that point. The impression should not be given that a decision on injustice or exceptionalism has been made when it has not. My lord, just as a matter of aside, in the English Court of Appeal, if you seek to reopen, you have to put it in writing, and it can be dismissed on the papers. And there's no hearing at all. The court considers whether you've made out a case for reopening on the papers. And I've been the unfortunate recipient of refusals in that exercise. But the jurisdiction, it is uncertain. And I know there's the Northern Ireland case of Walsh, but that was on the very boundaries of propriety, if I can put it that way, of applying these tests. Just saying that basically they got it all wrong in the last Court of Appeal. But so it's an incredibly important jurisdiction, but it does require some clarification. It may be that the solution is to interpret it in the light of the Constitution and give it a generous interpretation, and then that would solve some of these problems. But my lords, that's 69 and 73, and then the court has, so then summarising from then on, Court of Appeal had implicit power. There was a residual, Roman 2 we've summarised at page 231, residual discretion to decline to reopen an appeal even when the criteria had been filled. However, if it was right that an appeal should be allowed, the court should not decline to allow it, simply because it would burden the court with similar applications. And that's 104, so I can take the court to that. Any discretion, this is page 492 at the top. So it's a matter of discretion. They've said that at paragraph 103, the first point, it said discretion. Any discretion must, of course, be exercised on proper grounds. And then they make the point that you've got to balance the interests of the accused, the public interest in good order, finality, certainty and closure, and interests of the victim's family. But, and then it deals, those courts who consider the problem have realised that any solution may appear harsh on someone, but those courts have dealt with constitutional challenge or the equivalent, have decided that the right approach is that their decision should not, subject to affect closed cases. Well, that we respectfully submit is not an accurate summary of the totality of the jurisprudence.
So what's inaccurate?
Well, those courts that have dealt with constitution or the equivalent have decided the right approach is that it should not, subject to rare exceptions, affect closed cases. I mean, there are cases, my lord.
Sorry, those words appear where?
End of 104.
Have decided the right approach is their decision should not, subject to rare exceptions, affect closed cases.
Yes, good.
I mean, we've given citations in the case of cases which have suggested that the presumption should be in favour of retrospectivity. But as I say, I'm trying in this case to fashion a remedy that suits this case. Then there's a number of principles. The second principle is at 109, is that in deciding whether, at page 493, whether to allow these appeals, we should decide what the Chief Justice should have decided as to the application of his decision to all previous cases if he had been asked to address the question. And then the third principle is at 1112, page 494. Third, I have not forgotten the approach and principles laid down in the cases referred to above, ending with Johnson. And then it deals with the Joji case, where basically, my lords, at the end of Joji, the Court of Appeal said this won't necessarily apply to all future cases.
All past cases.
What?
Won't apply to all past
I'm so sorry. I'm so sorry. It won't apply to all past cases, and it will only apply where the substantial injustice is shown. So that's the reference to what the reference to Joji means. And they make the waiver point, which my learned friend makes at 113 point, could also have been taken at the first appeal, and we've dealt with waiver in the reply, which is still living in limbo, but which we respectfully submit deals with the question of waiver. And then 115, fourth, there are usually exceptions to every rule, as the courts recognised in Arbor Hill, that exception being referred to at paragraph 61 of CADA. And I would accept there may be wholly exceptional circumstances in which a subsequent decision as to the unconstitutionality of a statute should be applied to a closed case, but it seems to me that such a case would have to be wholly exceptional, and that the fact that the decision went to the constitutionality of a statute or provision, including one relating to jury selection, would not of itself make the circumstances wholly exceptional. To quote Arbor Hill, that's the Irish Supreme Court case. The grounds upon which a court declares a statute to be unconstitutional or some feature of an individual case might require, for wholly exceptional reasons, related to some fundamental unfairness amounting to a denial of justice, that verdicts in particular cases should not be allowed to stand. The use of the phrase wholly exceptional was intended to convey the hurdle was very high, and it should not, in my view, be watered down in application. And that exception, the Arbor Hill exception, was not in Arbor Hill held to be applicable, even though the statute under which the accused was convicted was held to be unconstitutional. Well, my lords, the Arbor Hill case was a case where the merits were pretty clear. This was someone who knew he was having sex with someone under 13, and they declared the statute to be unconstitutional, but there's no doubt in any, as it were, common sense of criminality that the criminality was there. So one can see why in Arbor Hill they laboured to find an exception on the facts. But in the present case, this is 120 at page 496, what is said is that the FIO... that's
what page, sorry?
Page 496, my lord.
Yes.
This is at page 496, 120. In the present case, this is the informed observer, would have thought that there was a real possibility of bias in the mode of selection, which may have appeared to favour the Crown. And if there had not been a relevant disparity, different people might have been on the jury. The result might have been different. In other words, there was a combination of possibilities. One, the composition of the jury is biased. Two, that if it had not been, the result might have been different. But in the cases before us, there were no more possibilities. These were no more than possibilities, each of which would have had to be actual for the accused actually to have suffered a substantial injustice. So that's the test of actuality, not just a possibility, which is the normal apparent bias test, but actual bias having an actual effect. And that's paragraph 120, and then that's, my lords, I think I can skip then to the key paragraphs that I took you to at page 509, paragraphs 189 and 191 in particular, where, without saying it's a hard and fast test, there's a strong indication that in case of apparent bias, you're looking for actual bias and causational probability. So 191, page 509, in short, looking at the matter as a whole, I cannot regard this case as coming within the wholly exceptional category, however precisely it's formulated. I recognise that we do not know why the Crown stood by 4 of those that it did, but in deciding whether the case is exceptional, it's legitimate to take into account whether in relation to those where reasons were apparent or are now known, the proposition that the Crown was fixing the jury in its favour, that if it had not, the result would probably have been different, carries any, and if so, what degree of conviction. In my view, it does not carry any real conviction, and certainly not one amounting to a strong case. So, my lords, that's the test formulated in Roberts.
And what's the reference in 191 to taking account of those in relation to which reasons were apparent? Was there a background that there had been some challenges for cause? and 4 were unexplained.
Yes.
So is this them saying, well, we can see the Crown legitimately challenging for cause, so there's nothing to suggest that they were actually actively seeking to skew the jury?
My Lord, I think that's right. There is, we've skipped an enormous degree of analysis of the facts of the case, which your Lordship will see. I think your Lordship has correctly summarised. If you look back, we see the case of Brangman at page 501, and they deal with the various jurors. So, and the schedule of the Crown at paragraph 148. So the exercise was conducted so far as it could be. Yes. My Lord, maybe some assistance, paragraph 159, my Lord, page 504. I would, so this is in one of the cases, that's to say Brangman. I would accept that there were in fact 6 Crown standbys, but as I have indicated, that does not seem to me to bring the case within either Arbor Hill or the Johnson exception. In particular, it's apparent from what was said by Counsel for the Crown why she was standing the jurors down, which was that she said they knew the witnesses or the victim. It does not seem to me the FIO would at that time think it possible, or that we'd now regard as either possible or likely. Crown was activated by bias. Yes, so that does seem to be nearing an actual looking at whether an apparent bias would be made out if one took the view of the reasonable, well-informed observer. My Lord, I hope that answers the question.
Yes, thank you.
So, my lords, that's the case of Roberts. And then if we look at this case, really, just in very brief summary, we've dealt with it at part 6, page 232. In very brief summary, the Supreme Court applied Roberts, which it held to be binding on it, at paragraph 25, page 16, and of the record, they held that Roberts was binding, and they applied it in this case, and we've set out the passage in the case, and then they said the same test should be applied as in a constitutional motion as on an application to reopen, and that's at 6.2. That's paragraph 28 of the record, page 17. And then they said that should the decision in Roberts not be strictly binding, it would nonetheless be followed, and that's at paragraph 26, at page 16. And then, but the ratio we accept was, of the Supreme Court was as an alternative remedy in reopening. And we've set it out in the case, the key passage from paragraphs 30 to 31 of the judgment of the Chief Justice. My Lord, unless you want me to read it out, you can see there that in essence, the court accepted the submission that the applicant has an alternative means of legal redress. And in the Court of Appeal, where the President, or Justice Clark, the President...
I mean, it seems to me that's predicated on the Roberts jurisdiction in a criminal, on reopening a criminal appeal being adequate.
Yes, my Lord, absolutely.
So it seems to devolve down to, is that adequate?
Yes.
Adequate reaction to the constitutional rights?
My Lord, yes, and I hope it's now clear what we say about that. We've set it out in some length, but in the case we say there are procedural defects to the reopening procedure. You just put in the application, you may or may not get a hearing. There's no appeal. Obviously, when they don't reopen, the criteria are...
Sorry, you're now referring to what?
Oh, in our case, we've set out why we say that it isn't an adequate remedy. My Lord, that's set out in the case at part 9, page 254 to 258. And your Lordship will see these points that I'm seeking to make set out at pages 255 to 256 as to why it's inadequate.
Well, you don't need leave to bring a constitutional proceedings, but what's wrong with a filter?
Well, my lord, you mean a filter where you don't actually get before the court at all?
Yeah, well, the filter is a requirement for leave and to reopen your criminal appeal.
Yes, yes, but with a constitutional motion, you get before a court.
Yes.
And you can,
Well,
my
get
lord,
the same result.
sorry.
You potentially get the same result. If the case does not get past the leave stage,
Yes.
don't you anticipate that you would get the same result on a constitutional motion? That is, if there is no arguable... What's the test for leave?
You don't need leave in a constitutional motion.
No. What's the test for leave in the criminal case?
Well,
Right.
leave to reopen.
Yes, is that, yeah.
Well, that's the problem, is that we, because it's not...
An arguable case in relation
Well,
to...
that's the first time round.
Yeah.
But we don't know what the test is in relation to an application to reopen, because what you do is you write in, I'm just trying to say what actually happens.
Yeah.
You write to the court, you say, I want to reopen this because something that was said at the last hearing has turned out to be completely wrong, and it was invalidated, and you get back a short, or you could get back a short sentence saying the Lord Justice has decided that this case will not be reopened. Now, at least with a constitutional motion, you get in through the door of the court, you address a court.
And is there any right then to go to the full court to renew your leave?
No, there's
And what are the provisions? The leave application is made under what provision?
Oh, it's now covered by the criminal procedure.
Yes.
What's the procedure? No, to reopen. No, there is no. Sorry, I'm so sorry.
There's no procedure.
There is.
The test, you say, is the one you set out in your case about exceptional circumstances and
Yeah,
so
yes,
forth.
yes.
And that's a judicial test, is it? A judicially formulated test.
Well, yes, it's been formulated and refined in various cases, my lord, yes.
But it's not incorporated in as it is in, you say it is in England, in the English criminal
I think it may be in
procedure
the
rules,
criminal
but-
procedure rules now it is. Sorry, I don't
Yeah, it's Rule 3615. It's in the supplemental bundle. It's page 46.
This is in
my
England.
lord. This is in England.
yeah.
So the criminal procedure rule.
Oh, yes, in England, but
It's not codified in Bermuda.
no.
No, in Bermuda it's not codified, my lord. But so you write in and say a substantial injustice occurred in my case, and I suppose you then set out what it is you say brings your case within the substantial injustice, why you suspect actual bias applying the Roberts test, and why you say it would have made a difference. I don't know quite how you ever established that, and then I assume that the judge can say, I'm going to invite the prosecution to comment on this, but there is no right to a hearing, there's no right to call evidence, there's no right, so there are real procedural defects about there's no right of appeal, obviously, either.
But you say the test to reopen, is that set out in your written case at 5.2, citing the Court of Appeal at 69?
Yes.
And you don't quarrel with that?
I don't quarrel that that's the test that's laid down, my lord. The only question is the procedure for giving effect to it.
But is the normal procedure in Bermuda the same as it is here if you want to appeal? That
Oh, yes.
You apply for leave, and then
Yes,
if it's
yes.
rejected on the papers, you can renew it orally?
Yes, it is, yes.
So you can renew it orally?
No, but you're saying it's not applied to these cases?
No, so if you're appealing for the first time, you've just been convicted and you appeal for the first time, you can put in your application for leave, and if you're refused, you can renew it. So it's the same as in England. If what you're doing is saying, I want you to reopen the closed case, you then we're governed by the procedure laid down by the President, Sir Charles Clarke, in
Christopher Clark?
Sir Christopher. Sorry, forgive me, Sir Christopher Clark.
Right.
And that's all there is.
But tell us where we find that.
Well, my lord, you'll find that set out in the passage that I took the court to at paragraph 73, page 482.
Of Roberts or?
Of Roberts, my lord, yeah. So, my lord, paragraph 73, page 482. In future cases where leave is sought to reopen the appeal, the court should, if it deals with matters separately, either refuse leave if satisfied there is no adequate basis for thinking the matters relied on might cause the court to give leave, or indicate it is prepared to consider whether or not leave should be granted at some future hearing without actually granting leave at that point. So it's very, I mean, we have very little to go on.
Right. I mean, that doesn't seem to address the question whether you can apply to renew your application for leave orally.
No, my lord, I'm so sorry, all I can go on is the English procedure. And,
I mean, this just really mirrors the procedure in England, certainly in civil cases.
Yes.
No right to an oral
the
hearing.
Taylor and Lawrence.
The Taylor and Lawrence. But I mean, the Lord Justice or Lady Justice, I think, will always give short reasons for refusing leave.
Sometimes very short.
Well, not, I don't think.
Well, sorry.
Anyway, let's not go into it, but they do give reasons.
In Taylor and Lawrence, yes, but,
Yeah.
but in the criminal context,
I see.
it can be.
You're saying that because there isn't an oral hearing, it's a defective procedure.
Well, it's not an adequate procedure.
Not adequate.
If the Constitution says, have you got an adequate available remedy? But my lord, the point I have respectfully made to the court is, were the court to graft onto that procedure sufficient safeguards to comply with the Constitution, then some of these arguments would fall away. All I'm saying is that at the time that he made his constitutional motion, there wasn't an adequate available alternative remedy. And my lord, just historically, and it may be of assistance, it started off as a very, very attenuated jurisdiction developed in cases like Majeski and Grantham, where you had to be able to say, the Court of Appeal didn't hear me, I was supposed to be there and I wasn't, they didn't notify me, or my lawyer didn't turn up, so I didn't have a hearing at all, it was a nullity, and that's analysed in the case of Berry, which again we put before the board. It had to be something fundamental like that. It's true that it appears to be developing so as to go more in line with the Taylor and Lawrence jurisdiction of the Court of Appeal in civil cases. And there is a case.
I think even in Taylor and Lawrence cases, you have to show that there was in effect a denial of justice, don't you?
Yes.
Yes.
I mean, classically, that you haven't had a hearing. Or there's been some fundamental misconception.
Exactly.
Yes, my lord, yes. So it's a very, very, in essence, it's developed out of a notion of a nullity. You know, I didn't have a hearing at all, and that the Berry case does analyse.
Well, one must have to be very cautious about adjusting procedures, because this is a procedure specifically limited to a situation where there has been a finding that there has been a constitutional breach, and the procedure should be limited to that. Otherwise, you have every single type of case being reopened.
Yes.
And so you're content with that?
Am I content on the?
Yeah.
Well,
that it should be limited to the.
Yes, in this case, definitely. Yeah. Yes, absolutely.
And the sufficient safeguards you seek are what?
Well, my lord, one, there should be a hearing, and two, there should be some mechanism for resolution of factual disputes. Because if you went on the constitutional route, you would have a hearing and you would have a mechanism to resolve factual disputes.
But just on that, on my understanding, if the appeal is reopened to examine factual matters, that would include a mechanism to examine factual disputes.
Court of Appeal can sometimes decide factual questions, can't it?
Yeah.
Have evidence. I mean,
Oh, yes, my lord. No, I accept that, and indeed, on the most innovative exercise of the reopening jurisdiction is in a case called Walsh, which my lord will probably know, where Lord Kerr basically reopened a case because basically it had gone through the Criminal Cases Review Commission. They'd sent it to the Court of Appeal. The Court of Appeal hadn't done what the CCRC had asked them to do, and basically it was saying they just got it wrong. I mean, that, in summary, I mean, you've got it in the authorities, but that was pushing at the very boundaries of this jurisdiction. My lord, so, but to answer...
And sorry, just on the first of the things you mentioned, why is absence of a hearing in itself a failure to afford adequate means of redress? If this discretion, which is going to be judicially exercised, is clearly bounded by principles, is capable of meeting the concerns about justice, why is the fact that you have to get leave to show you've got an arguable case to that effect something which prevents you having an adequate means of redress?
Well, I suppose, my lord, at the time, there's two questions. One, when the applicant made his application for constitutional redress, was he able to say, I do not have an adequate means of redress? We say historically he did, he could. The other is, could it be perfected by a judgment, say, of this court?
Sorry, just trying to understand on the first thing. So I understand your point in relation to the test in Roberts being too restrictive.
Yes.
And if it is correct that on analysis the test in Roberts is too restrictive, I can see the logic of saying, well, that's not an adequate means of redress, it's too restrictive. Therefore, something else needs to happen. So I follow that. What I'm struggling to see is, just suppose the test in Roberts were adequate to meet the injustice in this case. Why the interposition of a requirement that you have to apply for leave, i.e. to persuade the court that you've got an arguable case that that you're going to be able to satisfy the Roberts test? The interposition of that leave requirement makes it not an adequate means of redress.
Well, my lord, simply the importance of an oral hearing.
You say that in every other leave application you have a right to an oral hearing, and that this shouldn't be treated differently.
My lord, that's my respectful submission.
Right.
But
I thought I thought in Taylor and Lawrence that you don't have a right to an oral hearing. Things will be looked at.
That's right, but they are civil proceedings rather than criminal.
So does it come to this, that these are criminal proceedings? In other contexts where you're asking for leave, you get an oral hearing?
My lord, yes.
And so there should be one.
Yes,
Is that what the submission is?
My lord, yes, it is.
All right, okay, thank you.
In other contexts in criminal proceedings, you get an oral hearing. I suppose you can always challenge the refusal of leave by the single judge to the full court.
That's right.
Yeah.
And usually you don't get funding for that, mind you.
Well, that's another issue again.
That's another issue again. That's right.
Oh, my lord, we've crossed that bridge. But you can turn up, and as this client very eloquently did, you can. This
people do in the criminal division.
Yeah.
No, but my lord, I won't get into that deep water now, my lord. But I do respectfully submit the oral hearing. So we say, I think it might help to show you the case of Ramanut, because that just very shortly, because this question of...
But so just before you go there, I'm just trying to understand what the procedure would be.
Yes.
So would one be within the scope of the ordinary procedural approach that the Criminal Court of Appeal would apply? What's going through my mind is, I mean, if the ordinary position is you ask for leave, if you don't get it, you have the power to renew to the full court. Why does that not apply in relation to these sorts of?
Well, I think it's a matter of just history and procedure. You put in the application. In England, you put in the application. It's dealt with by a Lord Justice. The Lord Justice looks at it and on the papers and can say there's nothing in this.
You say it should apply. The ordinary procedure should apply in these contexts too. It's just the test will be the substantive test will be higher, but the same procedural approaches they should apply.
Yes.
And my question is, are we sure that it doesn't apply?
Well, my Lord,
My Lord, sorry to cut across my learned friend, but it may assist. I'm told by the DPP that it does apply. So if the Court of Appeal refused an application on paper to reopen, then the applicant renewal.
So it's the ordinary procedure.
It's the ordinary procedure, yes.
Oh, right.
Okay.
oh well, I have to say, is that written down anywhere?
I'm told there's a form that an applicant will have to. Yes.
Well, then in that case, it's better than the English procedure.
Right.
I'm very glad.
That objection falls away.
Sorry.
That objection falls away.
Well,
then, if that be correct.
If that is correct, that you can have an application to reopen orally, but so we've set those grounds out. My Lords, I'm grateful to my learned friend, but we would actually like to see chapter and verse on that. My Lords, if we look at the test...
Sorry, just to say, the chapter and verse goes both ways, because you're relying on this to show that it isn't an adequate remedy. So, I mean, you ought to be presenting us with submissions as well on that, shouldn't you?
No, I accept that, my Lord, yes. We asserted that in our case, and it was not contradicted your Lordships you will see that in our case we set out a number of reasons why we say the remedy is inadequate at Part 9.
So what paragraph? Sorry.
There's Part 9, page 255.
9.6, you say there's no right to a hearing.
No right to a hearing.
Matter may be dismissed on the papers.
Yeah, so we've asserted, I think we've asserted that all the way through in our petition too. So this is the first time that's been contradicted. And what has happened is that the court will see, third is condition to reopening an appeal that there's no other effective remedy. We say, well, if there's a remedy under Section 15 of the Constitution, then there is another remedy. And fourthly, the critical assessment is whether the alternative procedure is adequate. The reasons already explained, submitted was not an adequate remedy. And fifthly, there was no difference in the test to be applied. Well, then the court can deal with it itself. And my Lord, it's just this, before leaving this point, I think I ought to show the court because that is...
Well, sorry, just before you do, I think we do need to be clear what the legal position is in relation to 9.6. Are you don't cite authority for that, you don't cite rules for that. That's just your understanding.
Yeah, my Lord, yes. That's the procedure. There's nothing in Sir Christopher Clark's judgment which says, and you'll have a right to a hearing. He just says leave can be refused, where he's dealing with the procedure. As I've said, this can be dealt with on the papers.
But Sir Christopher Clark at paragraph 73 in Roberts, page 482, well, I was rather reading that as him just saying it's a form of application of leave to reopen an appeal.
Yes.
So there will have been other cases where leave has been sought to reopen appeals. And I think what we're now being told is that the way it works is you apply in writing, but if you don't get the answer you want, you can renew orally.
Oh, my Lord,
If that's right, Sir Christopher Clark seems just to be saying that it's the normal procedure that applies. He doesn't seem to be saying, but there'll be a departure in these sorts of cases from the normal procedure.
No, my Lord. All I can say is the only information we have about the procedure is in that.
You were saying that on what you understood the procedure to be, it was inadequate, but if it's correct that, as we're now told, there is a right to renew, then that particular objection won't
My Lord, I do accept that. I do accept that. It is true, my Lord, that we were going very much on what we understand to be what we know to be the position in England. But if one looks at, can I just, because it is important, to look at the case of Ramanui, it's in the Trinidadian situation where it's a discretion to refuse, but the principles are all set out about how, and we accept this. We accept that.
But what page is it?
It's page 338, my Lord, at tab 4, page 330 of the authorities. And one sees that there's a reference to a body of case law about not from misuse of the court's process, not misusing the court's process where you have an ordinary common law remedy. And at paragraph 23, page 346, starting point is the established principle adumbrate in Harricassoon. Unlike the constitution of some other Caribbean countries, the Constitution of Trinidad and Tobago contains no provision precluding the exercise by the court of its power to grant constitutional redress if satisfied adequate remedies are otherwise available. The Constitution of the Bahamas is an example of this, and obviously so is Bermuda. Nor does the Constitution of Trinidad and Tobago include an express provision empowering the court to decline to grant constitutional relief if so satisfied. The Constitution of Grenada is an instance of this. Despite this, a discretion to decline to grant constitutional relief is built into the Constitution. Section 14.2 provides the court may make such orders as it may consider appropriate for the purpose of enforcing a constitutional right. In Harricassoon's case, the board gave guidance on how this discretion should be exercised, where a parallel remedy at common law or under statute is available to an applicant. Speaking in the context of judicial review as a parallel remedy, Lord Diplock warned against applications for constitutional relief being used as a general substitute for the normal procedures for invoking judicial control, and saying you can't have resort to section 14 solely for the purposes of avoiding the necessity of applying in the normal way for the appropriate judicial remedy. In other words, where there is a parallel remedy, constitutional relief should not be sought unless the circumstance in which a complaint is made includes some feature which makes it appropriate to take that course. As a general rule, there must be some feature which at least arguably indicates that the means of legal redress otherwise available would not be adequate. And to seek...
Sorry, just on that.
Yeah.
So, is this right, that Lord Diplock is referring to applications for judicial review where you would need leave?
Yes.
And comparing that with applications for constitutional redress where you don't,
Yes.
he seems to be saying the fact that you have to apply for leave in judicial review does not make that inadequate. Indeed, you should be pursuing judicial review and go through.
No matter what.
Right.
Yes. Well, what you've got...
So applying that to our case, I mean, that seems to indicate that the interposition of a leave requirement before you get to the remedy under the ordinary law is not a basis for concluding that there's an inadequate means of redress. I was just going back a little bit to what we were debating.
Yes, no, my Lord. Well, of course, I mean, one can renew and one does get a hearing in judicial review in the end.
Right, okay.
But at least as a general rule, but my Lord, really this is the test, that some feature which at least arguably indicates the means of legal redress otherwise available would not be adequate. That's the test I invite the board to apply.
It's a different constitution. I mean, we should just be referring to our constitution, the constitutional provisions in this case. It uses the word adequate, and that's no more, no less than...
Yes. Well, my lord, your lordship's judgment in the Farringdon case does deal with a remedy, so I should perhaps take the court next to that, because it deals with it where it's mandatory, and one sees at part tab 8, the Harrington case, where
Page?
it's, well, I'm just going to try and get you the right, page 426, my lord.
426.
Yes, page 426 of the authorities bundle. This is where my Lord Stevens, giving the judgment of the board, states at paragraph 86, the board is satisfied that adequate and indeed identical means of redress are available to the appellant by way of an application to the board under the Pinochet jurisdiction. Therefore, the board is precluded by the proviso from granting any constitutional redress on the appeal from the dismissal of the new constitutional proceedings. This means that the appeal is dismissed on that basis, and the only procedural route to be taken to bring this matter before the board is by way of a petition under the Pinochet jurisdiction. The board will determine this case on the basis of the application under the Pinochet jurisdiction. And then there's an application of the Pinochet. I think in Pinochet, although it was a bias on the part of the board itself, the test was some real injustice. The language was, is there a real injustice? And so my lord applies the application of the Pinochet jurisdiction to the facts of this case and sets it out. And there is, in that case, there was an error in the sentence that was passed, and it was self-evident it could be put right. And so one sees the board exercising the Pinochet jurisdiction at paragraphs 87 to 90. And one sees at paragraph 89, given the serious procedural error, the board varies. This is at 89, page 427. The board varies its 1996 advice and humbly advises His Majesty that the life sentence imposed on the appellant is quashed. The appellant should now be resentenced. Resentencing should be remitted to a lower court. So, my lord, that's... And, my lord, the other point that we do respectfully make is where a case has got to the tertiary level already and been dismissed at that tertiary level, there's a question of whether you can go back to the Court of Appeal and say, relist my case before the Court of Appeal.
This is your new point.
Well, this is the Berry
number 2.
The Berry case, yes, my lord, yes. That's to do with the hierarchy of courts, really. That this case had come to the Privy Council where leave was refused on a conventional conviction appeal. There is a question, my lord, as to whether the jurisdiction is then in this board to reopen or the Court of Appeal. And my lord, I'm genuinely drawing it to the attention of the court because it seems a real problem. Not because I'm saying that's a great thing, because we obviously don't, we'd much rather there be a jurisdiction to go to the Court of Appeal. But I have referred the board to the case of Berry in that context. And that, does the board have that supplemental bundle? Yes, it's supplemental bundle, but my lord, just
I've got something headed further supplemental bundle. Is that the one?
yes, if it's got Berry in it. Yes, that's right. It's tab 2 at page 22 starts Berry, and then this was a case where we sought to relist before the Court of Appeal because they hadn't dealt with some of the grounds. They decided the case on the first ground and allowed the appeal. They didn't have to deal with grounds 2, 3, 4 as a result. It goes up to the Supreme Court. The Supreme Court there reversed the decision, but that leaves undecided grounds 2, 3 and 4.
They didn't make clear whether they were remitting whether the other grounds should be considered by the Court of Appeal.
Or whether they were going to, no, they didn't deal with them themselves. I think there were various things that happened in that case. My lord, that was exactly, my lord. The point is really just one of, it's one of the hierarchy of the courts, but you can see it at page 28. It says, thus, once an appeal reaches the House of Lords, in this case, the Judicial Committee, we take the view that a party to the appeal has a final opportunity within the appellate system laid down in the Criminal Appeal Act to bring such points as he wishes to make to the notice of the House. It is, of course, a matter for the discretion of the House what they hear. He has but one appeal which may involve a number of points touching upon one or more bases. House of Lords regards itself, we believe, and in our view, we say with respect rightly, as giving a final judgment in the appeal before it. Having done so, it makes its order. In the present case, the order was in effect that the conviction be restored. It was restored accordingly. It would be extraordinary, in our opinion, unthinkable, if the Court of Appeal were to be in a position thereafter to pronounce upon other grounds of appeal and thereby destroy the order of the House of Lords by again quashing the conviction. Now,
those were the grounds that were extant at the time of the appeal to the House of Lords, whereas this is a sort of case where something new arises later and you want to go back to the Court of Appeal like you do on a...
Absolutely, my lord. Obviously, we've got the Harrington case where, in fact, the hearing, the renewal, the reopening was before the board itself, so it can happen. But that was because there was a defect pointed out in the way it was handled by the board on the earlier occasion. So, my lord, I'm not advocating for excluding the Court of Appeal jurisdiction, but I am saying that it's not clear what the position is. Once you've gone to the tertiary level and they have finally disposed of the case, is any relisting before that court which last dealt with it or before the Court of Appeal?
You say that on the basis that there was an application to the board for permission to appeal against the original dismissal of the first appeal.
My lord, yeah, that's it. So if the board says, well, that's no problem, no problem, fine, but we're accumulating a number of reasons why this appellant could reasonably say, well, I'd rather go with the constitutional route where I get into court, I make my complaint, and it's dealt with on the merits. If the board concludes that on a generous and procedurally correct interpretation, the power to reopen is sufficient, then the board has our submission, which is, please exercise that jurisdiction now. Ramanoop says you can, if you're in the wrong box, they can convert it into a normal proceedings by writ. But we would simply say, and I think in the Farringdon case, there was a constitutional appeal before the board, and the board quite understandably said, no, we're going to deal with it ourselves. So we submit that you can to do justice in this case, and we would respectfully invite the board to do so, simply say, the matter is before us. We reopen the case and remit it to the Court of Appeal to decide those factual issues, which will have to be determined. That's to say whether the Director of Public Prosecutions account is accurate, or which is disputed by the appellant. Because obviously he gives a different account. And it may be necessary to hear to resort to the records in order to, I think there is a recording in existence in order to resolve those issues. We're not inviting the board to resolve that issue. So, my lord, that's how we put the point for the appellant.
The recording is of the process of impaneling the jury.
I think that's right. There is, yes. Yeah, the jury selection, yes. I think there is I see my learned friend nodding. So there is these matters could be resolved. My lord, that's in essence how. So, if I can just take you through the way we put it in our case, then very shortly, we've summarised at under ground one.
So before you go on, so just to summarise, the reasons why you say the reopening the appeal to the Court of Appeal is inadequate because, first of all, procedure, but you're satisfied that if there's an oral hearing, that's met. Secondly, the tertiary level point that you just raised.
Yes.
Okay. And thirdly, the test is incorrect. Those are the three.
Yes.
Yeah, that's fine.
That will do. Yes, my lord.
You don't take issue with the abstract test, but you take issue with the way it's been applied to this situation.
My lord, yes. And can I just say this, my lord? I accept that there was a strong strain of authority in the board saying that where you have a normal criminal appeal, you should pursue that rather than a collateral constitutional attack. And I can just give you the case of Bow. In the case of Bow, which was an attack on the mandatory death penalty, the Court of Appeal in Bahamas said, you shouldn't be here attacking the mandatory death penalty. You should be taking a constitutional motion to attack the mandatory death penalty. And we said, no, we're appealing against the constitutionality of the sentence in the criminal appeal. And Lord Bingham upheld that point and said, that's the right forum, as it were, the normal criminal appeal, not a collateral constitutional attack. So I accept that and Chocolingo, which my learned friend has cited, there's a whole series of cases which say that the correct procedure generally is to go by the available criminal procedural route rather than by a collateral constitutional attack. So I have to accept that that's the position. It's only if we can identify some real inadequacy or lack of availability of remedy that we would defeat the 15-2 point. But then, my lord, we submit that the test that was applied in Roberts was wrong. And we say that apparent bias is sufficient. Now, my lords, can I just take you to...
Sorry, just on that,
Yes.
because your answer to Lord Legate's question slightly confused me. I just want to be clear. My understanding is you do say that the test in Roberts is wrong in principle. It's not just the application to these facts.
Oh,
No, sorry, when I meant the abstract test, what I meant is you accept the conditions for reopening an appeal that are set out in your case, I believe.
Yes.
It's on page 231 of the bundle.
yes.
Circumstances exceptional, no other effective remedy,
Yes.
whatever,
Yes.
used would suffer substantially.
yes.
But what you don't accept is the way those have been transposed, if you like, into this context of this
Yes.
situation of
My
jury
lord, yes.
apparent bias.
Absolutely. And our submission, I hope it is clear, is apparent bias is something absolutely fundamental. If there is apparent bias vitiating the impartiality of the tribunal, that is a substantial injustice. And one has to differentiate, that's the first point. The second point is you have to differentiate between those change of law cases where you're saying the substantive law has changed, for example, Arbor Hill about carnal knowledge, how it's defined, or Joji, joint enterprise, and cases which are to do with fundamental fairness or fundamental impartiality, which is this case. And we say that in those cases, you are retrospective. If you look at the case of Bentley, years later, Lord Bingham and the Court of Appeal looking at whether Derek Bentley had a fair trial, applied contemporary standards on fairness. And we say so too in relation to the issue of impartiality. If we've, as it were, an illumination has dawned that limitless or very greater number of challenges by the prosecution gives rise to an appearance of bias or lack of impartiality, that is a development in understanding of whether the court was impartial, and that development therefore is retrospective. And so, my Lord, rather than arguing in the abstract about whether judgments are retrospective or prospective or not, and there are cases both ways, and we've cited, for example, can I just give you the reference? We've cited the case which says that the general rule is, the general rule is that they are retrospective in the Spectrum Plus, which we've set out at 7.9, where they say, page 237, a presumption that remedies will be retrospective, particularly in criminal cases, and the Treasury and Ahmed case. But if one tries to develop a test, in what circumstances should it be retrospective, and in what circumstances should it be prospective? We say that once it's clarified that a position under which you were tried gives rise to an appearance of bias or lack of impartiality, that should be retrospectively applied, because it's to do with a dawning sense of what's fair and what's unfair, just as with natural justice. It's different from saying, well, this statute applied or didn't apply. It's about fairness.
Well, I mean, it is a point you could have taken at the time, just like any other point about the fairness of the trial.
Absolutely.
And it doesn't follow that because, you know, you now say that my trial wasn't fair and I've got a reason I didn't think of or put forward in my original conviction. That's a good enough reason to re-argue it, isn't it?
Well, my Lord, we did try and deal with this question of waiver, and that's in the...
I don't think it's waiver. I think it is those people who are sitting in a courtroom having a fundamental appreciation of what is fair or unfair in that courtroom. And the fact that the point isn't taken is perhaps a reflection of how it impacted on the people at the time. And there are many criminal cases which apply that test.
Well, my Lord, can I just in seeking to respond to that, make just 2 points. Firstly, appealing to case law. In Miller, Lord Bingham says people have been appearing before assistant to court.
In Miller, were they balancing the right of the public to have criminal cases decided so that witnesses and victims are vindicated and the criminal justice system is upheld?
I mean, in other words, if you've been tried by an assistant recorder, you could complain about that retrospectively as a result of Miller. And Lord Bingham deals with the question of should you be deemed to have waived it in the Miller and Dixon case. So again, we put that in the reply or the short document that we applied to put before the court.
Do we have Miller in our...
Yes, my Lord, you do.
authorities?
Yes, my Lord, you do.
And which particular bit of Miller?
My Lord, if you just give me 1 minute.
It's on page 994.
So Miller and Dixon, yes, it's tab 31, page 994 onwards. In Miller, Lord Bingham dealt with the point as to whether there'd be a deemed waiver if a point was not taken at trial. He made the point the law was not entirely clear.
Sorry, you're reading.
What are you reading?
This is from the summary of our submissions that we put in.
Paragraph?
It's paragraph 3.1.
Sorry, where is this?
My Lord, I hope the court has it. There's an application to admit this.
Oh.
Well, why don't you take us to it in Miller, if you wouldn't mind, so we can just see it in Miller. I think that would be better.
Yes, absolutely, my Lord. So if you go to...
We've not admitted that document, Mr. Fitzgerald.
Okay, well, my Lord, it's a paragraph 31 of Miller.
Miller, thank you.
Miller is at tab 31, and
Error 31 at page 1008.
and so one sees there that Lord Bingham states there, paragraph 32 may be the most helpful one. Did the accused then make a voluntary, informed and unequivocal election not to claim their right to be tried by an independent impartial tribunal or to raise no objection to the temporary sheriffs before whom they appeared as a tribunal which was not independent? There is no suggestion that any reference was made at any stage in these cases before sentence to the standing or qualifications of the respective temporary sheriffs. Thus, any election, if made, must have been tacit.
Is this a closed case? Is Miller against Dixon a closed case? Or is it an appeal?
Well, just each of the four was, yes, criminal proceedings, convicted. Yes, my lord, the summary of the facts are at page 996. Roxton. Yes, yes. High Court, yes. Yes. So it wasn't raised in the original court. It was raised by the...
So they were ordinary appeals, basically.
Sorry,
they were regular appeals.
Regular appeals, yes, my lord. That is right.
In which it was said, or the question was, well, you should have taken the point at the trial if you objected.
Yes, absolutely, yes, my lord, yes. But he deals with the point. He says the test is: do you know that this is wrong at the time you're before the? Is it?
No one is challenging the proposition that if you had raised this as a constitutional issue at the time, you'd have got a remedy for it. The issue is whether or not it's how you deal with it, where there is a closed appeal and years later it's being raised. The crime was committed in 2012. He was tried in 2014. We're now in 2025, and.
Well, my lord, the answer is the fact that it is of assistance to ask oneself the question: was it a sufficiently notorious or clear point that by not taking it you can be deemed to have waived your right to take that point?
If I may say, it seems to me that there are two really quite distinct principles. Waiver: if you've actually waived something with full knowledge of your rights, you say, I don't want to pursue that. That just cuts it out as a relevant factor at any later stage. It's a complete answer. Yes. I think what's being said here is not that you've waived your rights, it's just that the feature of the case that you could have raised this at the time but didn't is potentially a relevant factor when one is bearing in mind the balance of different interests that come into play in the sort of closed case that we're dealing with here. So that's not a waiver case. That's just saying,
well, my lord, if it's not a helpful, but can I nonetheless take you on to another point in the same while we're here, where Lord Hope is dealing with the importance that page 1018G, appellants were unable to show that they would derive any real benefit from being retried or sentenced again. This is Lord Hope's judgment.
So, page
so which paragraph?
1018, paragraph 62.
Okay.
Unable to show that they would derive any real benefit from being retried or sentenced again. Invite us to hold the decisive factor in these cases was not the right to an independent impartial that had been waived, because no plea and bar of trial had been taken at the outset, but the use of temporary sheriffs in these cases made no difference, in fact, to the result. In my opinion, this argument overlooks the fundamental importance of the Convention right to an independent impartial tribunal. These two concepts are closely linked. The appearance of appearance and impartiality is just as important as the question whether these qualities exist in fact. Justice must not only be seen to be done, it must not only be done, it must be seen to be done. The function of the Convention right is not only to secure the tribunal, it's free from any actual personal bias, requires the matter to be viewed objectively. And then I know that the rest of it will be familiar, but it's the fundamental nature of that. And they're saying it wouldn't have made any difference. And one sees the same point about once that's raised, you don't inquire further at paragraph 65, at the last sentence, paragraph 65, page 1019. But my Lord, can I therefore make this point that if we are right that lack of impartiality or lack of an appearance of impartiality is something fundamental that vitiates the hearing, then we submit that that should be retrospective. And we've given you the reference to the cases where it said when we were dealing with someone in prison because of a law or a procedural approach that was unjust, or has now been perceived as unjust, then retrospectivity does apply. So, my Lord, that's the basis on which we say that apparent bias is sufficient to constitute the substantial injustice which justifies the reopening of the case. And we say, in answer to the point, well, my learned friend certainly does take the point, well, if it was so unfair, why didn't you take the point at the time? The answer to that is, it wasn't an obvious and notorious point at the time, but moreover, it was in accordance with the statute. The statute said you can do it. So you can understand both counsel and the appellant not taking the point.
So I'm not sure that I follow that. Wouldn't it, at least theoretically, have been a potential argument to say this statute is unconstitutional, therefore the court should not be following it?
Yes, my Lord, yes, but one of the interesting points is they did exactly what all the cases say you can't do, which is they actually had to go outside the criminal court to a constitutional court.
But sorry, I thought you cited an opinion of Lord Bingham saying that if you have a constitutional objection to the validity of a law which is being applied to you in criminal proceedings, yes, you can take it in the criminal.
Yes, you can. You
well,
can. No, but I'm saying, but in this case, because
so they could have done.
My Lord, they could have done, but it's not as if this is something that everybody knows, or because right. I mean, so and what Lord Bingham is talking about is it a notorious? Is it something obvious? I mean, the fact that the Court of Appeal in Bahamas only 10 years ago was saying you can't even raise the point in these procedures, you should go outside and seek a constitutional motion, is a factor.
It was raised in Trott.
Yes. So
it was raised in the criminal proceedings, wasn't it?
Yeah. Well, it wasn't actually raised in the criminal proceedings. No, because they took a constitutional motion.
I see.
You see,
well,
I know.
At what point in Trott did that? Was there a conviction? And I mean,
no, it was before. It was what you'll see it set out in Trott, my Lord.
Yes.
The counsel tells the judge, we are going to start constitutional proceedings to challenge 5091.
I see.
But
and the trial or the criminal proceedings are, as it were, adjourned to permit that.
Yes, and then there was the declaration that 5091.
But it seems there are two different situations. One situation, as you see in your case, that the prosecution are challenging juror after juror, apparently on the basis of their colour, of their skin. I mean, there, whatever the statute says, yes, you would have a complaint potentially that you're having an unfair trial. It may be that they've got, in principle, a right to exercise, but there's nothing says they're entitled to exercise that right in a discriminatory way. And there's another situation where you say, well, just the very fact that they have more challenges than I've got makes the thing unfair.
Yes.
And that's a much less obvious situation.
Yes, I mean, as my Lord Sells has pointed out, in fact, it is the case that you could have raised it in the High Court. You could have said before the trial judge, I want you to deal with this constitutional point. But the fact that
anybody could have raised it any time in the last 10 years.
Yes,
because it must often happen they get challenged more. Yeah, well, we know it does.
The very fact that no one's very clear how you do it or what you should do.
Well, I mean, you could also do it by way of an abuse of process application.
Well,
and I mean, there are numerous challenges that you could have.
Well, my lord,
if it was being used abusively, then you could have stopped the criminal proceedings.
Yes, well, you challenged the jury panel for an indifferency. Yes.
I wasn't seeking to suggest that it was notorious that this was a defect in the law. I was just picking you up where you said that there was somehow an impediment, a theoretical impediment in the point being taken in the criminal proceedings because there was a statute in place. And I was just pointing out if the statute's unconstitutional, I couldn't see why you couldn't challenge that then and there.
I'm sorry, my lord, your lordship's absolutely correct. You're absolutely correct. Conceptually, you're absolutely correct. Well, but the point I'm trying to make is insofar as it said you didn't take the point, we say it wasn't notorious, it wasn't obvious. There appeared to be a statute which authorised what was the process of selection that took place. So that's the first point we make. And the second point we make is that when it's said you've got to point to a substantial injustice, we submit that if one looks at what Lord Bingham says about the importance of avoiding appearance of bias and what Lord Hope says about that in the Miller case, this is a substantial injustice. And it falls into the category of in natural justice breach, which once one's appreciated it, can be retrospectively applied and relied on. My lord, it's sufficient.
What's more fundamental, the fact that an offence doesn't actually exist at all, as in Arbor Hill, or the appearance of bias, which didn't strike anybody at the time?
Well, my lord, I think, and I know your lordship will be very familiar with the Arbor Hill. The criminality undoubtedly did exist. It was, but my lord, we don't invite the court to follow Arbor Hill. We say that that the best guidance on this issue of retrospectivity is to be derived from the case of Spectrum Plus, which we've set out the relevant passage at 7.8. The force of a void law would become dependent upon when the first person had the foresight to raise the relevant argument. And they say, and this is set out page 237 of our case, prospective or limited retrospective application can cause unfairness. And we've just quoted, this is from paragraph 27 of Spectrum Plus.
Sorry, can you just give me your paragraph number in your...
Yes, if 7.8 in the case, my lord, page 237. Born out of a laudable wish to mitigate the seeming unfairness of a retrospective change in the law, prospective overruling can beget unfairness of its own. This is most marked in criminal cases where pure prospective overruling would leave a successful defendant languishing in prisons. Selective prospective overruling avoids this consequence, but it could see a successful defendant freed while others in like cases stayed in prison. So that case, Spectrum Plus, suggested that the general rule should be retrospectivity, particularly in criminal cases, rather than the Arbor Hill, that the general rule is the other way round. And we've also referred to the Treasury and Armid, HM Treasury and Armid at 7.10 on page 238. We submit, obviously, that we've set out some sentencing cases at 7.12. You don't continue to serve a sentence that has been found to be unconstitutional because it's been imposed in the past and not appealed. I accept that sentencing may have a particular be in a particular category. And therefore we submit that the general presumption should be, in this type of case, that's to say where there's recognised to be a breach of the rules of natural justice, retrospectivity, and that it does constitute, in our case, a substantial injustice. And my lords, the conversion of the case, I know that my Lord Stevens was giving the judgment in the case of Farringdon. There was in that case a constitutional application, but that was, which had appealed up, but that was, as it were, put on one side on the basis that it was more appropriate for the board to reopen the matter. So this board, which was last seized of the matter when it refused leave to appeal, all those, I think 2015, 2017, could simply reopen the matter and then remit it to the Court of Appeal to decide on these bases. My Lord, that's the way that we put the case. My Lords, so we invite the board to reopen the matter, and the jurisdiction to reopen, I should just make, I think, just this point, that the Taylor and Lawrence procedure in civil cases has now been applied to criminal cases in England and Wales, and that's in the case of Yassine at tab 53. Can I just show the board that? So the Yassine case, page 1836, held reopening the appeal, setting aside the earlier order. This is at page 1836. Where there's been a defect in the procedure which might have led to some real injustice, the criminal division was vested with a residual jurisdiction to avoid real injustice in exceptional circumstances. And I mean, that was an extreme case. So that's just to indicate that that's the most recent decision applying the Taylor and Lawrence jurisdiction. And you'll see, the most, yeah, lengthily reasoned case. If I take the court to page 1842, it sets out the various powers to revise an order when it's been recorded, to revise whether the order is a nullity, and then over the page at 1843, the power to revise an order whether there's been real injustice, and it sets out the case of Daniel and the case of, over the page at page 1844, the case of Pedley and Berry also. So, my Lord, we say that this board has the power to reopen the case. It can exercise that power informed by the Constitution, and should do so in a manner that obviously affords procedural fairness, and that the fairest thing to do in these circumstances would be to, in our submission, reopen, but then remit for issues of evidential dispute to be resolved by the Court of Appeal itself. And obviously the board's quite familiar with remitting matters back to the Court of Appeal for determination. And I think the board has my submissions as to why the approach in Roberts is unduly restrictive, and you have my submissions as to how this matter could be converted. In the Ramanoop case, which the board has at, we looked at it briefly, but you can see that the board talk about converting a constitutional motion into a writ action.
Can you give us the reference?
Yes, my lord. It's at page 348. Yes, paragraph 30, my lord. What then of a case whereon the information available to an applicant, a constitutional motion is properly launched, later becomes apparent that there is a substantial dispute of fact or that a claim for constitution is no longer appropriate. And we'd say that that fits this case in many ways, and where appropriate direction should it be given for expedition and timetables set for further steps in the proceedings. So that's, as it were, converting it from a constitutional motion into an ordinary writ action in the same way the court could direct that what started life as in a very different situation after the judgment in Roberts as an application for constitutional relief should continue as an application to reopen. The board has all the facts that are known so far before it and has the submissions of law on both sides of the appropriate test. So, my lord, we submit that the board can do justice in this case by converting it in the way that the board suggested in Ramanoop. I think my lord, I think I've said all the things that are in it, but you have my application that I would like the board to consider the further submissions we put in. We had served them on my learned friend 10 days ago, and then there were various procedural problems about serving them, but I do make that application.
Well, we're not going to we're not going to accept the further pleading. However, we have had the benefit of your oral submissions this morning, for which we're grateful.
I'm very grateful. Page 483. Oh yes, I'm very grateful to my learned friend. It's in the record, is it? Yes, in the record at page. It's in Roberts, is it? Oh, it's in Roberts. I see. In Roberts at page 483, the reference to 40 to 50 people. So it's. Yes. So maybe we can track down. So page 483, paragraph 78. Paragraph 78. Yes, I see. If paragraph 78, page 483, if the finality principle is not applied, there would be a real prospect of a large string of cases in which second appeals against conviction would be brought, stretching back indefinitely. We were told by Mr. Pettingill that there was something like 40 or 50 cases where there was a prospect of a second appeal, and that the actual number of appeals might be substantial. These might paralyse the appeals system. If standing by more than 3 is fatal, it could apply to very... Yes, I see. If standing by more than 3 is fatal. But of course, we're not saying that that's necessarily fatal in every case. If it were now necessary to visit old cases in which the Crown had exercised its rights, going back for an indefinite period, there would be great difficulties in determining many years after the event what exactly had transpired when the jury was selected. Notes that were handed up might not be available. So the practical problems are identified by the Court of Appeal.
It looks to me as if 40 or 50 cases, there seems to be an actual prospect of an appeal, rather than there simply being the fact of more than 3 challenges. That's how I read that now. There's a contrast between 40 or 50 where there's a prospect of a second appeal, and that the actual number of appeals might be substantial, i.e. more than that.
Yes, my lord, I think that must be the right reason. I'm grateful. Yes.
It could be the other way.
Could be, but
it doesn't really explain how the 40 or 50 is calculated at all, does it?
It says if standing by more than 3 is fatal, it could apply to very many cases, which I think must be more than 40 or 50. That's how I read it.
Yes.
Anyway.
Well,
whatever it is.
My lord.
Well, very hard to perceive of the number of criminal cases that in which juries have been selected using this provision. I'd have thought it would be almost universal. I don't know.
You mean
whether it's how often it's used? We don't to challenge more than three.
Yes, I mean, there's certainly, if one looks, it certainly does appear to be more used in murder cases such as this, because one can see that in the new amending act, they've preserved the rights for greater numbers of challenge in murder cases than in ordinary cases. So maybe that's they don't bother so much in the other case. I don't know, my Lord. I'm afraid I can't illuminate any further. But my Lord, those are my submissions.
We're grateful. Thank you, Mr. Fitzgerald. Mr. Poole.
My Lord, I'm grateful. My Lord, I propose to respond to the points, I think, in the way that my learned friend has taken them. So I'll first deal with ground 4 first, which is section 15.2, because that makes more sense. That is, we say, case dispositive. And I should say, not only because we say that the reopening jurisdiction provides adequate means of redress, but there is a prior question, which so far I don't think has really engaged the board, which is whether there were adequate means of redress. There are two questions that need to be asked. So if the board was satisfied that, in fact, at the time of the original trial, there were adequate means of redress, which I say quite obviously there were, but they just simply were not exercised, we say that is a complete answer and precludes the board from exercising constitutional relief under section 15.2. And that's, my learned friend's only answer to that is the waiver point, which for reasons I'll come on to explain, we say is not an answer. But that's perhaps what I think in the debate we've had so far on section 15.2 has not been sort of aired, so I do want to take some time to explain what I say about that. Second, I'll deal with ground 1, which is the retrospectivity argument. I may be able to take that briefly because we've set it out in quite a lot of detail in our written case. And then third, I'll deal with grounds 2 and 3 together, which is how we've dealt with it in our written case. That's the applicability of the test for reopening appeals in Roberts to generally, and also to the facts of this case, so cases of apparent bias. Lords, then, looking at 15.2, if we can turn up 329, please, which is section 15.2 of the Constitution. And obviously we are concerned with the last paragraph of subsection 2.
Sorry,
Page, so when on 330, my lords, is the specific paragraph we're concerned with. So provided that the Supreme Court shall not exercise its powers under this subsection if it is satisfied that adequate means of redress are or have been available to the person concerned under any other law. So in my submission, we're obviously dealing, the other law here is the Court of Appeal jurisdiction in criminal appeals. The question that the board should ask itself is, first of all, have adequate means of redress been available? Only if the answer to that question is no, then do you need to consider, are adequate means of redress available? So only if you answer that first question in the negative, does the board in fact need to engage with the question whether Roberts is an appropriate test and whether reopening provides adequate means of redress. And so as to that first question, and this is the point we make, it's paragraph 29 of our written case, which is page 268. So this first question, if the appellant felt a sense of hopelessness and despair watching the selection of the jury take place, which is what he says at paragraph 10 of his first affidavit, which is at page 41, there was nothing preventing him either raising the point at trial, as Mr. Trott did, by way of a constitutional motion, or raising it at appeal.
But doesn't any other law mean it has to be under something other than the Constitution?
Although I think probably it would have to be under the Court of Appeal Act. It would have to be a criminal appeal. So
I mean, you can't say that because you could always have raised the constitutional point, therefore you've always had an effective remedy. That can't be right.
No, my lord.
You'd have to have an ability to challenge his conviction without relying on the Constitution. And I can see that may be the case if it's a sort of actual bias situation, maybe, but surely otherwise, this challenge based on the fact that it's unfair because the statute gives a right to the prosecution to stand down as many jurors as they like, that requires a constitutional challenge, doesn't it?
My lord, no, it wouldn't. It would be something that you could raise on appeal, because the infringement is an infringement of your constitutional right, Article 6, to a fair and impartial tribunal.
I thought you accepted that the challenge can't be under the Constitution itself; it has to be under some other law than the Constitution.
My lord, yes, but it would be a criminal appeal. So the other law would be a complaint of unfairness. And this is what Lord Bingham, in fact, says this is the right way to go about this. So it wouldn't be a constitutional motion alleging breach of Article 6. It would be a criminal appeal in the normal sense of a criminal appeal. But you would be raising the fact that you've encountered unfairness because of the way that your jury has been selected. But
what do the prosecution say? Well, that's what the statute says. You know, it gives us you can't say you haven't had a fair trial because the statute provides for this procedure.
My lord, there are two, though, and this is sort of explored with my learned friend. I mean, there are obviously numerous complaints that could be made, but one complaint that could have been made is Mr. Trott's complaint that Section 519(2) is unconstitutional.
Yeah.
And remembering that at this point the appellant was represented, so it's not this isn't something that he has to come up with. He's got representation. That was a point that was available to him.
But that was redress under the Constitution.
But the obvious point, and this is why if we look at what he says in his affidavit, and this isn't with hindsight. He's saying at the time, he says, paragraph 9. The Crown stood by numerous potential jurors, at least 15 to the best of my recollection, whereas my law was only able to challenge 3. Para 10, I felt a sense of hopelessness and despair as I watched the selection of the jury take place. Para 11, to the best of my recollection, most of the potential jurors who were stood by were predominantly black people who appeared to be under the age of 35 years, whereas the ones the Crown had no objection to were older white people or Portuguese looking. Para 12, I formed to the best of my recollections, most of the jury pool had been exhausted. It looked to me that, he says, the jury was stacked against me. Para 13, it felt like systemic racism right there in the justice system, a system which is supposed to be fair to all persons.
Sorry, what page was it?
That's pages 41 to 42, which is the first affidavit of the appellant. So the appellant argues that at the time of his trial and conviction in April 2015, and then his appeal in January 2017, an objection on grounds of apparent bias arising from the power to stand by juries was not, learned friend's words, an obvious and notorious point. Well, I say 2 points in response to that. First, that is not an answer to whether there were adequate means of redress available under the Constitution. That is an attempt at explaining why the appellant did not raise an objection to the jury selection. But then the second point, going to my Lord Legate's question, it's not a question of challenging the constitutionality of Section 519(2). Jury selection took place over 2 days, 30th and 31st of March 2015. The appellant, through his counsel, played an active part in that process. And we know that, leaving aside the potential factual disputes between the DPP and Mr. Gardner, the DPP's affidavit, which you have at starting at page 47, what we know from that is that the DPP has reconstructed the jury selection process based on audio transcripts. And we know that the appellant's counsel challenged 2 jurors, so played an active part in the jury selection process. We then look at what the appellant says in his first affidavit about how he felt at the time, having witnessed this. And assuming that is how the appellant felt at the time, he could and should have raised an issue either at trial or on appeal.
But what is the issue he would have raised?
Based on what he says at paragraph 10, that effectively the Crown has selected, racially profiled the jury.
The Crown was manipulating its powers
Yes.
under the jury selection process.
Yes.
But the challenge, forgive me.
I'm so sorry.
I was going to say here the challenge is to the very constitutionality of the law, not to its application in a particular case.
My Lord, no,
I mean, that's what Mr. Fitzgerald is building on.
The ability of the Crown to do that comes from section 519(2) before it was obviously reformed. But the complaint is, I have had an unfair trial.
But not because of the existence of 519, but because of its use in this particular case.
Yes.
But that's not quite the way that Mr. Fitzgerald puts his case, I don't think. Because he says that that 519 creates apparent bias, and that itself is fundamentally wrong. That's, as I understand his argument, the basis on which this appeal is made.
It's the finding in Trott. Yes.
Yes.
But Mr. Fitzgerald has to.
How would that have been raised in this case?
My Lord, the question is that the remedy that is sought is a retrial on the basis of apparent bias. I think Mr. Fitzgerald would accept that you have to go further than simply showing that the right of standby has been exercised. He accepts that in saying that it wouldn't apply to simply all trials that have taken place where this jury selection provision was in place.
He says it will apply whenever they challenge more than 3 people, whenever they've exercised the power.
But the question under 15(2) is whether there were adequate means of redress at the time for a complaint. The complaint at its heart is this is a breach of Article 6 of the Constitution. This is a breach of my right to a fair trial by an impartial tribunal. And so the redress that is sought is for redress for breach of Article 6.
Yeah, but then we keep coming back to the point that it has to be effective under some other law, and you can't use the Constitution as a circular thing to say that you've always had an effective remedy, because you could always have asserted your constitutional right.
The difficulty with that is that if one doesn't interpret any other law in a wide sense, then every single criminal trial is disrupted, because as soon as there's an alleged unconstitutionality, you rush off to the Supreme Court and you bring a constitutional motion in the Supreme Court. And I recollect there's a decision where we criticised that as an abuse of process, that the constitutional rights can be raised in the criminal proceedings. That is the proper forum for all the constitutional rights to be raised. That, to my mind, involves a slightly wider reading of any other law to incorporate a challenge in the criminal proceedings relying upon constitutional law. And unfortunately, I can't immediately recollect the decision, but it was a decision by, I think it was an ex-prime minister who was facing various charges and was constantly bringing constitutional challenges and delaying the trial and preventing justice from being done. Sorry? I can't remember.
My Lord, we say that the Section 17 of the Court of Appeal Act 1964 is the right of appeal to the Court of Appeal from a conviction. You've got that in the supplemental bundle at page 57.
Sorry, just before we move away from under any other law, isn't the contrast with Section 15(1), which says you've got the right of constitutional application? So I'm looking at page 329. So the other law is not that you've got to search around for some other law other than the Constitution to give you your rights. It's a question of how you get your redress.
Well, that's what.
So if in the criminal proceedings you could raise
Yes.
an argument which would be based on the Constitution, Section 5192 ought not to be applied.
Yes.
You would still, you're not precluded from saying, I could do that in the, the individual could do that in the criminal proceedings by the proviso to Section 15.2, it seems to me, because the contrast is between, should you do it by a constitutional motion or should you do it in some other procedure? So is there means of redress under any other law? That means other than the constitutional motion that you could bring under Section 15.1.
Yes, my lord, but that's...
the reason that I'm raising it is I think my Lord Legate was putting to you that you have to find some grounds of challenge to whatever has happened, which doesn't depend upon you relying on the Constitution. That was the
that was how I was reading it.
My lord,
I mean, the oddity is that in Trott, the criminal proceedings were adjourned so that a constitutional challenge could be made.
Yes. That's the case that I'm trying to recollect, where we term that almost an abuse of process.
Yeah.
I think Lord Sales was sitting with me in that case. And
I'm afraid that's not in my mind, but what is in my mind is the authority, the Lord Bingham authority that was cited to us this morning. My short-term memory last that long.
You can rely, I mean, I would say, obviously, but with respect I say obviously, because you can, if you're going to allege under Section 17 of the 64 Act on your criminal appeal that you have had an unfair trial, then you are obviously engaging Article 6 of the Constitution. And you're not precluded from doing so. And I say, when you're looking at 15.2, right, you are obviously looking at whether you've adequate means of redress, because ultimately you look at what the relief that is sought by the appellant in this case is, and it's a retrial based on the fact I've had an unfair trial and not in front of an impartial jury. And so I do say this first question is sort of case dispositive, because I mean the Court of Appeal in Roberts say as much, that effectively it's para 56 of Roberts at 476. They basically say, well, if the Court of Appeal was faced with an in-time appeal, they would have granted permission to appeal. And the short point is there was nothing preventing the appellant from raising...
Sorry, which was the paragraph?
So para 56 of Roberts at 476. There was nothing preventing the appellant from raising a complaint based on the jury selection in his appeal to the Court of Appeal and also in his appeal to the board. And the appellant tells us precisely what he considered was the issue at the time. It wasn't, he doesn't say in his affidavit, well, I was told by my law about section 519.2 and I thought that's a bit odd. He says in terms that his complaint was he didn't like the racial profiling of the jury. He thought the jury was stacked against him by the prosecution, and he felt a feeling of absolute despair, he says, which is similar wording to Mr. Trott in his affidavit. The appellant failed to take any of those steps, and I do say the result under section 15.2 of the Constitution is that the board, well, first the Court of Appeal, but now the board, is precluded from granting constitutional redress because adequate means of redress have been available to the appellant.
How does that sit with the ability to, in theory at least, to reopen, which in Roberts, the Court of Appeal?
My Lord, I say if I'm wrong or you're not with me on that first prior, has to be a prior.
Suppose we were with you on that. Where would that leave Roberts?
I mean, in terms of this appeal, it would mean that you would not. I mean,
wouldn't
there
it
always
mean
would have been an
wrong?
effective remedy.
I don't know. I don't think it would mean Roberts. No, it wouldn't mean Roberts was wrong.
But what? Sorry. isn't the force of this argument that if you could, in theory, have raised the constitutional objection to Section 519 at your criminal trial, which was the case in Roberts, you're precluded from doing so later on, once you've got to a situation where it's a closed case.
You're precluded from raising it, I say, under the Constitution, but Roberts was a criminal...
Yeah, so you wouldn't stop you going back to the Court of Appeal in exercise of its criminal power to reopen a case.
No, and I don't say at all that this is an answer to the appellant's application, because the appellant, I think my learned friend said, well, he has made an application to reopen his criminal appeal, and the Court of Appeal have effectively said, well, we're not dealing with that because you've got a constitutional appeal to the board.
Right.
That's not, and maybe
that's not work both.
But that's not quite correct either, because the Court of Appeal, in fact, and the timing of this is, well, I would say slightly odd. If you're going to maintain an argument that an application to reopen a criminal appeal is not an adequate remedy, what in fact the appellant has done is on the 29th of November 2022, he has applied to the Court of Appeal to appeal his conviction out of time, effectively an application to reopen. And you've got that application in the supplemental bundle on page 67. I think it's suggested, perhaps in a note that the board hasn't seen, I think it's suggested that we
haven't seen it. So
No, but I think what might be said is, well, we're not quite sure of the date, but in fact, if one looks at some of the documents, they've been stamped by the Court of Appeal by 5th of December 2022. So the Court of Appeal is seized, if you like, of an application to reopen as of beginning of December. That is 3 weeks before he files an application for leave to the board. That's on the 19th of December. So what the appellant has sought to do is, in fact, apply to reopen to the Court of Appeal first, then apply to the board to appeal his constitutional motion dismissal by the Court of Appeal. But then what the board won't perhaps have seen, it's page 66 of the supplemental bundle, is the Court of Appeal's letter to the appellant, which, rather than saying, well, basically, we're not going to deal with this, what they say is, we will not proceed with your application for an extension of time to appeal until the Privy Council disposes of your application. So it's not, perhaps as my learned friend might have suggested, that the Court of Appeal has said, well, sorry, we're not going to look at this. What they're going to do is they're going to deal with his application once this issue of the constitutional motion has been disposed of. And I don't say, because I'm looking at this purely because this is an application for constitutional redress under Section 15. I don't say Section 15.2 has anything to do with the Court of Appeals exercising its discretion to reopen a criminal appeal.
So in fact, I think the logic of the argument isn't directed against Roberts, but would be directed against Trott, I think, wouldn't it? Because that did proceed by way of constitutional motion while criminal proceedings were on foot, whereas you say that actually was wrong.
Yes.
If this argument.
Yes.
Okay.
So I say for those reasons, 15.2 is case dispositive because adequate means of redress have been available. But if for whatever reason I'm wrong about that, then obviously we do need to engage with the reopening jurisdiction, and I do say that provides adequate means of redress.
I mean, we should probably engage with it anyway because it's going to be live one way or another, and as the case has got here, it seems sensible that we do. My Lord,
yes, I wasn't proposing to ask for a sort of summary judgment actually on that first point, but I just wanted to make it up front because I do say actually it is unanswerable with respect, because the only answer is the waiver point, which it's not a waiver. We're not in waiver territory. But yes, but as to whether adequate means of redress are available through the jurisdiction to reopen, as is the position in England and Wales, so Taylor and Lawrence in a civil context. And then my learned friend rightly says, Yassain is the decision that basically confirmed that the Taylor and Lawrence jurisdiction applied in a criminal context. The Bermuda Court of Appeal has an implied or implicit power to do, using the words of Taylor and Lawrence, to do what is necessary to achieve the objectives of the appellate court. So that obviously includes a residual jurisdiction to reopen a concluded appeal, and that's been confirmed obviously in the case of Roberts. And that's at paragraph 69 of Roberts that I think the board has been taken to. It's page 481. What we say adequate means of redress means is that redress has to be accessible and capable of vindicating the right that is relied on. I mean, the Court of Appeal probably put it slightly better than I have. It's paragraph 56, page 34. They say there must be a route by which the appellant can obtain a remedy if he is entitled to it. And so I say when we're talking about adequate means of redress, that is what we are, that's the question that has to be asked. And in my submission, an application to reopen can effectively address the appellant's constitutional grievance. And the test is that set down by the Court of Appeal at paragraph 56 of its judgment, as I've just alluded to. Lord, just on before I then embark upon why we say reopening is adequate, which will deal with also the Berry point, the new point. Perhaps in light of the time, I'll pause.
I'd like to do that in two.
Yes.
Thank you, Mr. Poole. We'll rise and I will sit again at 2.